All right, so the point is that the United States Supreme Court gives itself the most important judicial power, the power of judicial review, the power to be the sole arbiter of the meaning of the Constitution. So it's defined its own role. It says what it can do. And that reinforces for you the importance of understanding jurisprudence, because the United States Supreme Court gives itself such an important responsibility. It's important to us to understand how they decide these constitutional law issues. Should the Constitution, as we said, be applied literally, or should it be applied through a four corners of the document approach, as we have here? And what does that really mean? What does it mean to have four quarters of the document approach? Is it a strict interpretation of those words? Is it a more liberal interpretation of those words? You know, how do you actually do that? On the other hand, as we said, some people believe in the pragmatism approach or the living document approach, which says you have to adapt the Constitution to changing society, to changing circumstances. That a document that was adopted and instituted over 200 years ago cannot mean the same thing now as it did, I should say, 200 years ago. So that we have to have the ability to say how this particular constitutional doctrine can apply to more modern issues, so that we don't have to amend the Constitution all the time with every new development or technology or issue. As part of this, the other question that a lot of legal scholars ask is, what is the role of natural law versus positive law in interpreting the Constitution? So when we talk about natural law has been defined as higher law in accordance with nature, that's applicable to all men and women, and is unchangeable and eternal. So these are natural rights of human beings that exist regardless of any other law. That there's certain basic rights that we have, that we refer to as natural rights, that cannot be violated. So, is there such a thing as natural law? And a lot of our historians will tell us that our founding fathers believed in natural law. So what does that mean? Well, in order to answer that question, we also have to understand what positive law means. Positive law deals with the actual laws enacted by governmental authority, such as the legislature, the courts, the administrative agencies, the executive branch. And that's distinguished from natural law. So it's laws that are actually passed. And as we said, and if you look at Carper says that the founders believed they had incorporated natural law principles into the Constitution in a manner consistent with the necessity of government or positive law. They also believed there was a higher law that applied to all and was eternal. So the question is, when we try to evaluate constitutional law, especially in regard to substantive rights, what is the appropriate role of natural law? So if you believe in natural law, many people do, well, then the question is, if something is natural law, how do you know what it is? How do you know natural law? What do you refer to? A Ouija board? A Bible? The Quran? How do we know natural law? Is natural law whatever we happen to think it is at any particular time? Because if it is, then it becomes incredibly subjective. So one of the things that I would argue is that it's really hard to apply natural law to substantive constitutional issues. All right, so that kind of encapsulates some of this idea of jurisprudence. The next major issue that we want to talk about is we addressed what is the major role of the Supreme Court in regard to constitutional law. It is a sole arbiter, judicial review. It gave it to itself. We talked about how. So different jurisprudence approaches, and what we have to do whenever we look at a Supreme Court is look at the different judges and try and figure out what approach do they use to evaluate and understand constitutional law controversies. And then the last question that relates to this role of the Supreme Court is, who does this law apply to? So we're talking about, for example, a Bill of Rights, and we talk about these ideas of civil liberties. Who does the Bill of Rights and civil liberties apply to? And that might sound like a silly question. Well, they apply to citizens of the United States. Okay, well, what does that mean? So the Bill of Rights are the first 10 amendments to the Constitution. We need to ask, what do they mean? Who determines their meaning, and how do they apply to our society? And when I ask that question, that might sound like a silly question. Civil liberties, by definition, are protections that we are given as individuals. Protections against who? Protections against government. So government can't violate these individual rights. They can't take away our freedom of speech. They can't take away our freedom of religion and free exercise. They can't establish national religions and impose them upon us. So again, civil liberties are individual rights, and when we say that, we mean they're rights that protect us from government action. But what I want to know is, what does that mean? What does that mean? Does it apply equally to federal government and state governments and local governments? Well, interesting enough, the answer to that's pretty complicated. Most people just have assumed that the Bill of Rights applied to all levels of government now and forever. And guess what? That's not true. It's not true. As a matter of fact, until the last 100 years, the Bill of Rights did not protect citizens against the laws and violations of the United States Constitution by state and local government. Actions by state government and local government were restricted by only their own constitutions, not the United States Constitution. So when we start talking about the application of the Bill of Rights to government, we talk about this notion of incorporation. Incorporation of the Bill of Rights. And we talk about 3 different ways to incorporate the Bill of Rights. Selectively, or selective incorporation, non-incorporation, or total incorporation. So if you believe that the Bill of Rights applies to all government entities and always had, that would be total incorporation, that all the Bill of Rights apply and they've always applied. But as I said, that is not the way the Bill of Rights have been applied in reality by our courts. And an example of this is the case of 1833 called Barron versus Baltimore. 1833. And in this case, Barron sues the city of Baltimore for ruining his dock. Barron claimed that Baltimore had violated his Fifth Amendment rights by depriving him of his property without due compensation. Eminent domain. The Supreme Court looked at the city of Baltimore, looked at the Fifth Amendment, and they ruled against Barron, declaring that, quote, the Fifth Amendment is intended solely as a limitation on the exercise of power by the government of the United States and is not applicable to the legislation of the states. So tell that to your family members. That guess what? The Bill of Rights originally didn't even apply to state or local government actions. It only applied to national government actions. So as a result of this decision, what the United States Supreme Court said is that state governments were limiting their actions against their citizens only by their own constitutions. And that's important, because many state constitutions did not have provisions protecting things like freedom of speech, freedom of the press, freedom of private property. So in many states, if you criticize government, that was a violation of state law, and you could be jailed, regardless of the First Amendment. So in 1833, we had what was referred to as non-incorporation. Well, that's no longer true. We've rejected the idea of non-incorporation. And the question becomes why? Why do we reject non-incorporation? And what do we reject it for? So, what we have to understand is, what changed? What changed in terms of our interpretation of the application of the Bill of Rights to national, state, and local government? Well, what changed was the passage of the 14th Amendment. 14th Amendment was seen as a turning point. It was passed in 1868. It was passed after the Civil War, and it had two important provisions. It said, first, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So it's saying no state. So for the first time, a constitutional amendment specifically says a state cannot violate our privileges or immunities. Secondly, it says, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So, the question from a legal perspective became, what was the intent of the 14th Amendment? What was the intent? Was the intent to overrule Barron versus Baltimore, which called for non-incorporation, or not? Now, originally, the United States Supreme Court didn't interpret the 14th Amendment this way. So we have in the 1870s what are referred to as a series of cases called the slaughterhouse cases. And in those, the United States Supreme Court declared that the 14th Amendment was mainly intended to protect former slaves and did not protect most civil liberties against state interference except for fundamental rights. Fundamental rights. That becomes the key judicial phrase in regard to the application of the Bill of Rights to national as well as state and local government. So in other words, if it was a fundamental right, the states and localities did have to abide by it. So as we said, 14th Amendment was passed in 1868. And the United States Supreme Court doesn't establish a fundamental right in the Bill of Rights until 1925 in Gitlow versus the United States, in which they say, we may and do assume that freedom of the speech and press are fundamental rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. That's the first time they do that. So it's not till 50 years later that the United States Supreme Court finally interprets the 14th Amendment to apply the Bill of Rights to the actions of state and local government. Very significant. So that's where we are now. We do not have non-incorporation, we've rejected that. But we also don't have total incorporation because the court says that the 14th Amendment only applies to fundamental rights. So where does that give us? That gives us the idea of selective incorporation. So what happens is every right in the Bill of Rights, if it is being violated by a state or local law, has to be challenged, and the courts then have to determine if that particular right that's being violated is a fundamental right or not. And that's pretty much what the courts have been doing for the last 90 years, trying to figure out which parts of the Bill of Rights are fundamental and which parts are not. And in doing that, it has held that most of the Bill of Rights are fundamental. So, First Amendment's obviously fundamental, Fourth Amendment's fundamental, Fifth Amendment, Sixth Amendment, Eighth Amendment, all of those were considered fundamental and were decided fairly early on. The Second Amendment was one of the last parts of the Bill of Rights to be determined to be a fundamental right. And again, that was because there was tremendous disagreement over what the Second Amendment means. What the heck does the Second Amendment really mean? And if you read the Second Amendment, you can understand why the confusion. Second Amendment is the only Bill of Rights that has a prefatory clause. So in other words, it qualifies the right itself before it tells you what the right is. Second Amendment says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So, many judges have interpreted this differently, with many judges saying that given the way this was written, clearly the Second Amendment's not an individual right because it's being given in the context of a well-regulated militia. So it's not an individual right. And then other judges saying that it's just stating the obvious that you need a well-regulated militia and we still have the right to bear arms. And it wasn't until recently that we decided that this was a fundamental right. In the case of McDonald versus the City of Chicago in 2010. And by the way, I believe that that case is included in your book, so you might want to take a look at that. Well, given this approach, this idea of selective incorporation, because not all of the elements of the Bill of Rights have been incorporated, so it's not total incorporation. Parts of the Third Amendment and other parts of the Constitution have not been incorporated till this date. Then the question becomes, how do you apply it to determine whether or not something is a fundamental right? And there's actually a two-step approach to determining it. First of all, you have to ask whether or not we're dealing with a public or a private matter. So, as I said, in order for something to be fundamentally protected, we're protecting it against government action. So what's government action? What is a government action? Clearly, if the legislature passes it, it's government action. Is a policy by a college a government action? Depends upon the college, doesn't it? So, if you're a private religious school, is it different than being Ohio State? And the answer is yes. So there's like a continuum of public and private. Am I restricted by the Constitution in the privacy of my own home? So if someone comes to my house and says, hey, Desario, I want to come in and visit with you, and I say, I don't like blonde-haired, blue-eyed people, am I violating any legal right? And the answer to that would be no. It's a private action. Now, if I own a business, I own a restaurant or a bar, and someone comes in and I say I don't serve women, that might be a different issue. Is that considered a public forum or not? Well, clearly I engage in interstate commerce. So would that be enough to make me a public entity? So that's the first approach here. Are you dealing with a public or a private action? So first you have to answer that question. Is it public or is it private? Then the next question you have to ask is it a fundamental versus a non-fundamental right? And as we said, the court has pretty much gone over almost all the elements of the Bill of Rights to determine this for us. So if it deals with issues of freedom of speech, freedom of religion, clearly those are fundamental rights. So that's how we go about analyzing these types of questions. And that's what we mean by the incorporation doctrine. So, given that, what has happened is the courts have applied these principles to the notion of, say, civil liberties. Civil liberties. And what it means for the court now is, okay, so if we're dealing with the First Amendment, and we're dealing with an issue of religion, free exercise, establishment, and it deals with a public entity, we have to decide whether or not the state can do this or not. All right, so we know that there is selective incorporation. We know the First Amendment does apply to state and local action too. But now how do we resolve the case? That's the next stage. How do we resolve the case? And this is where we talk about this idea where I said that we've indicated that civil liberties are not absolute. So yes, we have the right to freedom of religion. But what does that mean? So the court, once it decides that this is an action that violates the idea of a civil liberty, then has to decide, okay, does this specific action fall in a category that government can do or not do? Because sometimes we can violate a civil liberty, but it's okay because it's an exception. Where do we draw the boundaries? So just to give you an example, let's assume we're dealing with a case on religion, and we're dealing with the free exercise clause. And an individual, as part of their religion, is an American Indian and wants to smoke peyote. Can his employer fire him if he smokes peyote? Now this might sound like a crazy example, but again, it's a true example. Smith versus Oregon Employment Services, a real case. Where an American Indian was smoking peyote, he gets fired by his employer, and he says, "You're violating my exercise of my religion. This is part of our religious practice," and he's right. It's been practiced by American Indians for 1,000 years. But can government do this or not? So now, the Supreme Court is left with the difficult task of saying what is covered by the free exercise clause and what's not. Can you smoke peyote? Can the state of Wisconsin pass a law that says that it's mandatory for all children within their state to go to school till they're at least 16? And I said, we have a right to do that because we want an informed and literate citizenry. And then if you're Amish, you say, this is against our religious practices. We don't believe that our students should have to go to school until they're 16. At a certain age, we want them just to come back to our communities and learn how to work on the farm. Again, a real case, Wisconsin versus Yoder. And what the courts do is they come up with legal standards. So in the area of free exercise, the standard the courts came up with was, does the state or local law have a valid secular purpose? A valid secular purpose. And if it does have a valid secular purpose, then the law is upheld. Same thing with the Establishment Clause. So, if you're an atheist and you're offended by the fact that your local government puts up a nativity scene in the middle of town, can you sue them and win, saying they're violating the Establishment Clause? Or if you're a taxpayer and you're offended by the fact that state and local governments are taking your tax money and giving it to parochial schools to pay for their teachers, and you say that's a violation of the Establishment Clause, it's promoting religion. Again, the Supreme Court must intervene, must decide these cases. They're not absolute. And in some of these cases, the Supreme Court has agreed that it's a violation of Establishment Clause. And in other cases, they said that it's not a violation of the Establishment Clause. And in that area, the standard they used for many years was called the Lemon Test. So they said that if the government policy represented excessive government entanglement and either prohibited or promoted religion, that it was a violation of the Establishment Clause. So the government comes up with standards. Free speech. To what extent can you say certain things? So, if you're a member of the Ku Klux Klan, and you go to a rally in Cincinnati, and as part of that rally, you say, the white man has been oppressed by African Americans and Catholics and Jews, and if this continues, we have to get our guns and restore order. Is that protected free speech? And by the way, that's another real case from Ohio, Brandenburg versus Ohio. And in that case, the Supreme Court has to decide what is protected free speech and what's not. Is it just protected if we like it and not protected if we don't like it? Remembering that Justice Black said that freedom of speech was the heart of our democracy. So we have to be very careful about regulating people's free speech, whether we like it or not. So they came up with standards, like, does that statement lead to imminent danger and harm, the harm to others doctrine? If it doesn't, then it's permitted. If it does, then it can be regulated. So if I say instead, hey, let's go get our guns now and kill us, some legislators, that would not be protected. Clearly. So what we're trying to indicate is that in this area of civil liberties, the Supreme Court has to decide, first of all, whether it's a fundamental right, and then if it is a fundamental right, does the state law violate that right or not? And then they come up with standards. All right, I'm going to stop here, and then the next thing we'll do next time we talk is I'm going to talk about the issue of federalism, which will be the last part of constitutional law, and then we'll start talking about criminal law. So make sure, like I said, you've read the chapter on criminal law. Thanks, and everybody have a great time out there, and be safe.